too many landowners are not clear in terms of why town and country approval is a thing, is essential. We cannot, and I want to talk about the 𝗧𝗧 project, for example. I feel like that's why I like that we are all, three of us are here, so that we can use case study examples to sort of build on that and highlight what is the issue and how the listeners can avoid it. So I don't know if you recall the 𝗧𝗧 project, where that client would have come to me, would have come to the firm just stating that, they would have already sold this property. Correct. That's what I'm saying. Let's follow what's happening here. They let people pay a $10,000 a month or whatever was their monthly installments. They had a sale agreement created by an attorney at law who did not take into consideration the fact that this was RPO lands. And she created a sale agreement. And in the scheduled portion of a sale agreement, she put, without surveying the land, she created her own boundaries, her own description, and she gave them 1 acre parcels. I don't know.
She's town and country herself.
We spoke about sale agreements. That's why we start. Look, Mr. Sylvester already rubbing his head, right? I'm explaining to you how we ended up in 𝗧𝗧. That 𝗧𝗧 project started off because an attorney at law created a sale agreement or agreement for sale where she allowed the parties to transact in monthly installments for 1 acre parcels of land. And she described them herself in the scheduled portion of her own sale agreement. Now, agreements for sales, as we would have said in previous webinars, are not required to be registered. So that means nobody in legal affairs looked at this. It didn't require an attached survey plan for it. That just happened. When now they finish make all their payments and it's time for me to do the deed or the title, I can't do the title because these lands are under the RPO and they require subdivision approval. And to get subdivision approval, that's from the Town and Country Department, there are requirements that must be met to approve the excision of what to get those 1 acre plots, because they were like, I think originally they were like 5 acre or 16 acre or whatever. When we carried it to Mr. Sylvester, what did you tell us? Because they sold 4 plots. They got a draftsman to draw out 4 acre pieces and it looked nice. I realized that this is not approved plans. I come to Mr. Sylvester in the office, and do you remember what happened with that matter?
If I remember correctly, the lands were subdivided incorrectly into 4. You had a 4 acre parcel, subdivided lands into 4 1 acre parcels with no consideration for access. So basically, it was dead on the door from the beginning. We did reach out to, in that particular matter, we did reach out to Town and Country Planning for advice because, as you said, money's passed.
Yeah.
And now, this is something people need to understand too. I guess we could talk about it later on, but Town and Country is not beholden to anybody with respect to you have a sale agreement or you have a will. There's a policy in place and they follow the policy, right? So in that area, I think the land was agricultural, but they were willing to give, for that parcel of land, 3 to subdivide into 3 as opposed to the 4. So there's one person, if they sold all 4, I can't remember, if they sold all 4, then one person is out.
Yes. And that's something, sometimes the late person believe, well, I have a 4 acre parcel of land, so I can sell 4 people 1 acre.
Yeah.
But can you, not because you have a 4 acre parcel, mean that you can get 4 1 acre plots.
Yeah, correct.
Why is that? Could you explain that? Because I'm seeing people just get vexed with attorneys, and when I have, Ms. Daniel, I have 4 acres of land. Why I can't sell 4 agricultural land or sell it 4 acre? Why I can't do that?
It's fairly simple, in the sense that unless you are the luckiest person alive and you have the correct amount of road frontage, where each person on their 4 acre can get and have it the proper now town and country. There's something called length to depth ratio. So for every 1 meter you go with ways, you could go 2 meters down the road. So when I say you have the proper amount of road frontage, you have enough that the length to depth ratio stays within town and country, and you can get the land in 4. That means your land thin and narrow. Most people don't have thin and narrow lands. Either lands are fairly square, some of them are a little odd shape. So basically you have to cut a road. Road access typically is a 33-foot or 10-meter wide road. In some instances you can get a road smaller, 7.5 meters or 25 feet, depending on if it's about 2 to 3 lots that are being serviced. And I just said lots, not acreage. So once you take out a 10-meter wide strip from your parcel, there's no way you can get sorry, let me just take this off. Sorry. Yeah. Good God. Yeah, sorry. Technology, not good at it. There's no way you can get 4 1-acre parcels. You're gonna end up with something either 3/4 acre or oh my God. I don't know why I connected my phone to the
computer.
Right. So what happens is that in this case, the town and country policy was specific to a 1-acre parcel. You couldn't go less. So there's no way you can get. So the parcels will be slightly larger in this case than 1 acre, but you couldn't go under 1 acre. Anything under the 1 acre would have been declined again. So you had to go with 3 parcels of land to be serviced by this road. Okay, once you start taking out things, okay, another good example is everyone says an acre land is 8 lots. But nobody takes into account the fact that you have to put a road to service. Yes, so we normally say here a gauge is 6 lots to an acre because you're taking out. But as you talk about more and more land, town and country requires you to take out more and more stuff from the land in order to meet specific requirements. Which
so
is
the bigger the land, the more requirements.
What things town and country gonna ask you to take out in order to meet what is called density, have to have proper density controls in the area. All right. For instance, if you are on a 3-acre parcel, I saw somebody talking about a 3-acre parcel in one of the chats.
Yes.
Right. If I have a 3-acre parcel, I want to subdivide it. I have to give up 10% as a green area. That is 3/4 acre already. That's gone. Right. I have to give up a nursery school site, which is roughly 2 lots. I have to give up a site for institution. An institution maybe like a commercial area, like for, let's say, a little mom and pop supermarket, something like that, to that effect. That's another 2 lots gone. So you see, you don't have 3x8, 24 lots. You may
the full 8 because it has to
18,
right. And so part of getting
when you take out
getting it on country approval.
As I say, as you go bigger, more stuff is going to be asked of you to give up. It's not straightforward as people think it is. Did I go around in a circle?
Understood. No. It was good. We have a question from Chinda.
Yeah.
Am I a follow-up
clear?
Last word.
Yes.
I have 3 acres. Right. I would like it into lots for sale.
Right. So
not RPO. What's approval required?
I don't know. I see like Mackenzie's frozen. It just threw me off.
No, he's not frozen. I'm hearing him. I realize you're not hearing and seeing him.
I'm not hearing or seeing him. It threw me off.
You hear?
Right. So in the case of going back to the 3 acres,
are you hearing me now?
Hold on. I am hearing and seeing the both of you all, but you all are not hearing each other.
No, we're not.
Let me see.
All right, let me.
I am hearing Mr. Paul. I'm not seeing him, but I'm hearing him. And so I think he's going to reset and come back. Right. Are you seeing him now?
Are you seeing me now?
I see a blank screen.
Wait for it. I'm still not seeing him.
All right, I'll reset.
No, Mackenzie, wait. Apologies for the technical difficulties. Yeah. Technology, but I'm hearing him.
You brought me on board.
Yes. No, but the audience is understanding, and we having the comments saying very concise. Thank you. They understand. I'm just gonna answer some questions here. I'm seeing gender. I believe to check tongue and country. Okay, so somebody answered gender. I don't know what's gender's question. Right. What is the role of tongue and country play in helping persons who have been adversely possessed in state land above the statutory requirement of 30 years?
You're dealing with state land, you need to go to the Commissioner of State Lands. In some instances, depending on where it is, it might actually be the Land Settlement Agency. But even though in the law, there is a stipulation that if you're on state land for over 30 years unopposed, then you can claim it. However, I don't think that has happened in decades and in my lifetime, and I am over 50. There are multiple reasons why.
I want to discuss that because, well, you know, we understand why we are laughing because we are in the field, right? And we know that fallacy unicorn of adverse possession that people try to arbitrarily talk about. It is a very popular word among the public, and they seem to believe, especially when you're talking about state land. I want to make it very clear.
Yeah, like, you know,
even though the law is there is a provision for adverse possession when it comes to state land. What is really required for you
against the state
quarter to satisfy?
And you have to basically ask this.
Yeah, it was breaking up. Yeah, what you really asking from the land. So yeah, so Paula, adverse possession does exist in Trinidad and Tobago. It is very much available for you in law. It is an equitable remedy for land possession. The 16-year requirement for private land and bringing that under the RPO is very different and happens a lot of times in Trinidad and Tobago. However, the person higher up would have asked in relation to state land. What do we mean by that? We mean lands that are owned by the government of Trinidad and Tobago that you as a squatter have been on for over 30 years, and you believe you have an equitable claim through tenure. Now you're trying to get title. Understand that you're asking, as Mr. Paul was saying earlier, you're asking the state to go against itself. That is essentially what it is when you try adverse possession for state land. We're not talking about private land, we're talking about state land. The state is naturally going to do what it can to protect their interests. Additionally, the documentation, notices Mr. Sylvester is saying here, you have to go to the director of the Commissioner of State Lands, right? Or the Land Settlement Agency. Now, when you have to now carry them to court, right? And say, well, they have extinguish their rights in the land, etc. You now have to submit surveys, right? That's what, Mr. Sylvester?
Yeah, but as I will tell you, one time you can't submit state land without the approval of the state.
I'm not going to say that. I'm walking them through why in reality. I don't want them to get too excited about it. State land adverse. I am being real. You all can see it here. What I'm walking you through, remember we had a webinar about adverse possession, guys. And what you have to prove it to the court is that not only were you possessing the land adversely, you were uninterrupted, all these different things. And one of the major things you have to submit are those survey plans. And guess what? Those plans have to be approved by the director of surveys.